thank you, Brighton SEO, for letting me come and talk to you about one of my favourite topics, cookie consent. Can we get a yay? That's better than I thought we'd have. Okay, so clickety-click. There we go. Oh, gone too far now. How do I get back? Go back. So yeah, I work in technology, mate. You can tell, can't you? So this is me. This is what I do. I am not in SEO, I'm not in digital marketing. I am in human rights and humanity and fundamental freedoms, and this is why I'm here. So I'm going to talk a little bit about the law around cookies and consent, bust some myths, give you some examples of bad moves, show you some examples of good moves, and then add my shameless plug. So all this law, why do we have all this law about data and technology and digital and all this? Well, the fact is that data is enormously powerful. I don't have to tell you that, you know that. Data is enormously powerful, digital technology is enormously powerful, and as the great Uncle Ben Parker says, with great power comes great responsibility. Why do we need laws that govern how we interact with each other digitally? Well, here's some examples. Worth noting, pretty much all of these, unintended consequences. These are not evil villains in their super volcano layers going, wah ha 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 ha, what can I do with data to mess with people's lives? This is just the effect of people being people and not thinking too hard about the future consequences of what they're doing with data. So this is why we have laws. What laws do we have? We have data protection law. Hands up if you've never heard of the GDPR. Ooh, okay, good. If I'd done this 5 years ago, I reckon there would have been hands. Okay, so GDPR, Europe's data protection law. Data protection law is not about protecting data so much. It's about protecting the living human beings, their rights, their freedoms, their welfare, their interests, you, me, everyone, us living human beings when we're represented in data. Because data isn't some abstract, different universe. When you're working with data about people, you're essentially handling bits of people. And when you handle bits of people, the polite and civilized thing to do is be jolly careful with it. Data protection law, protect individuals' rights. Something you may not know, which I find is quite common when I'm talking to people in digital, is that cookie consent requirements don't come from data protection law. They come from ePrivacy law. So while data protection law is all about personal data, data about human beings, ePrivacy law is about confidentiality of electronic communication services. And there's a very specific bit in ePrivacy law which says, basically, keep your hands and your eyes off client devices unless what you're doing is completely, strictly necessary for the communication to happen at all, or it's for a feature that the user has requested actively and intentionally, or you asked and they said yes. This is where cookie consent requirements come from. ePrivacy law has been around since 2002. It wasn't until the GDPR came in and supercharged the notion of consent that it really started to get traction. Don't worry, I'm not going to read it out to you. This is the bit of ePrivacy law that defines whether what you have to do with cookies and why. Please note, not just cookies. This also applies to local storage objects and tracking pixels and any data that could be read from or written to an end device over a web connection. So, unless the only thing this cookie is doing is making the transmission happen, or it's strictly necessary to do something over the internet that the user has requested, then you have to have consent. Dun dun dun. Please don't throw things at me, by the way. I didn't write this law, I'm just telling you what it says. So, things that don't need consent. This is easy, let's start here. This, for example, is a scenario where you don't need consent, where you have a login to a secure site. In order for the secure login to happen at all, a secure session cookie needs to be set. Great, it's necessary, no consent needed. Don't bother asking consent for secure login cookies. You don't need to ask for consent when a cookie is helping to coordinate the user session between various different types of web server. So you've got an app server here, your database there, and something else over here. You don't need consent if it's making the transmission happen. If you are balancing the load between servers, so content delivery networks, particularly for streaming media, nobody likes to have Wimbledon buffering when they're looking for that all-important shot. That's another thing where you don't need to ask for consent to set the cookies that make this happen. And you don't need to get consent for cookies that record whether or not you've had a yes or no to your request for consent for cookies. Consent. Yeah, bit of a roundabout one there, but that one's actually comes under the user feature. So if you're setting a cookie that says this person has said yes to cookies, you don't need to get separate consent for the cookie that says yes, this person has said consent for cookies, which is nice. And features initiated by a user, say if you've got embedded media on a page, when the user engages with that embedded media, you don't need to ask for consent to set a cookie. If you're setting all of the cookies just in case the user engages with the media, then you would need to get consent, because that's you essentially pushing a cookie at the user, and the user doesn't really know whether they need it yet or not. So embedded media, chat functions, geolocation, sync functions. If the user initiates, then you can set a cookie and not need consent. If the user doesn't initiate, you need to get the consent, or wait till they initiate. Consent, I keep talking about this word consent. What does this word mean? Well, in terms of data protection law, which is where ePrivacy law gets its definition from, consent has to meet pretty high standards to be legally valid. So those standards are, it has to be informed. The other party has to understand and know what it is they're agreeing to. So merely providing the technical specs of a cookie isn't going to give informed consent. You've really got to explain what this cookie is, what it's for, why it's there. Preferably in human language and not in geek. It's got to be freely given. So you can't say to an end user, if you don't give me consent for the cookies, I'm going to come and kidnap your dog. Because that wouldn't be freely given. Freely given means there must be a genuine choice. They've got to be able to take it or leave it. It's got to be specific. You can't go up to a user on your site and go, can we have consent for all things? Yep, great. You've got to tell them what it is you're asking consent to, what that looks like, and why. So a consent for type of cookie A does not necessarily translate to consent for type of cookie B. For example, if I came up to you and I said, can I borrow your pen? And you say yes, that is not consent for me to also take your phone. So it's got to be specific. Unambiguous. If I stood up here today, which I'm just about to actually, and said, by coming to this session today, you have all agreed to give me possession of your immortal souls. You'd be quite surprised, wouldn't you? Because as far as you were concerned, you were coming to hear me talk about cookies. You're sitting yourself in your chair was positioning yourself to hear me talk about cookies. Well, from my point of view, I can interpret you sitting in your chair as giving me your immortal soul. So consent has to be a positive action that is unambiguously agreement to the thing that has been asked. Now that's really important, and that'll come up in my examples of bad practice in a moment. And evidence is good. the evidence is not the consent. Consent is a state of relationship between parties. That relationship may exist whether or not there's evidence. The evidence of consent is only evidence of consent if the consent exists for the evidence to point to. So, for example, you can't wave an IP log at somebody and say, this is evidence that I have your consent, when they're saying to you, you do not have my consent. So don't confuse the documents with the actual state of affairs. Revocable. Consent has to be withdrawable or refusable to be meaningful at all. A choice that is no choice, you can't call it a choice, certainly not under data protection GDPR terms. So somebody has to be able to say no before the thing happens that they're saying no to. And they have to be able to come back later on and go, actually, do you know what, I've changed my mind, I'm going with no now. That is very, very important. If it's not revocable, it's not consent. So that's what consent means. Cookies that you absolutely have to ask for consent for and you can't set unless you get informed, freely given, specific, unambiguous, revocable and evidence consent. Anything involving advertising and remarketing. Sorry. Yes. There is no way that any of those are ever comms critical. Users might initiate the feature, but 99.9 reoccurring times out of 100, you have to ask for consent. Anything to do with tracking or profiling, again, not comms critical. If the user initiates it, the user clicks on the button that says, follow me around the internet, then go for it. But otherwise, you've got to ask for consent. Whether or not you're looking to generate leads from individuals or from businesses, ePrivacy law doesn't care. ePrivacy law is just about what's going on between your server and the end device. Not interested in who's who and what they're doing. It's all about the connection between your server and the device. Yeah, sorry about that. A/B testing, it's legit, it's useful, it's great, but it is not comms critical because it's not essential for the transmission to happen. You don't have to do A/B testing, it's a nice to have. It's not something a user initiates because if you tell the user they're getting a different version of a web page, then you kind of defeat the object of doing the random testing. So you have to ask for consent, which is a hard sell. Session analytics, capture, site performance, all of those things, they all need consent. Bear in mind here, there is a difference between law, risk, and ethics. I'm telling you what the law says. Risk of whether or not you get caught and punished for doing it wrong, entirely separate conversation. Ethics of, is it okay to do that to people if it's not in a lawful way and it's not what they expect? Another different conversation. I'm talking about law here. Bust some myths. First versus third-party cookies. You will not find these phrases anywhere in data protection or ePrivacy law. They're industry terms. They are completely irrelevant in terms of what to ask for consent for and what not to ask for consent for. They don't make any difference. It doesn't matter whose domain the cookie is attached to. If your site is reading, writing, or facilitating the reading and writing of cookies to an end device, then the cookies either be comms critical, user initiated, or you have to get consent. However, when it comes to data protection law, first versus third party does matter, because if you're sending data about your site visitors to somebody else, then data protection law says you've got to know about that, you've got to communicate that to people, and you may have to give them a choice as to whether to allow that. Personal data versus PII, that's my favourite one. Okay, so PII, personal data. PII is specific identifiers. So my name, Rowenna Fielding, that's PII, because it identifies me directly. However, the The nice lady with curly hair who stood up to talk about cookie consent at BrightonSEO on Friday, that is not PII because it contains no direct identifiers, but it is my personal data because together it points to me. It allows me to be singled out and recognised. So when you're talking, when you're explaining cookies to your site visitors, you need to be very careful that you're not giving the misleading impression that you're not processing their personal data, because you very well might be. You might not be collecting any PII, but if you're collecting their activity around the site, where they came from, their IP address, geolocation, device characteristics, then you are going to be collecting personal data. And the data protection law has some things to say about when you're doing that. It's got to be lawful, fair, and transparent, for a start. Categorizing cookies as functional or performance or essential in order to make it easier for people to understand what they are, great, as long as you explain those terms, because they don't exist in ePrivacy law or data protection law. Not so great if you're using them to try and get around ePrivacy law consent requirements, because, again, comms critical, user initiated, or get consent. Opt-out consent, contradiction in terms. You've either got opt-out or you've got consent. Consent is where you ask first, opt-out is where you do it and then wait to see if they screen. These two phrases do not belong together, ever. Legitimate interests, no. You cannot set cookies on the basis of legitimate interests, because legitimate interest is a data protection thing, and cookie consent is an ePrivacy thing. So in order to get cookie consent, in order to comply with ePrivacy law, you either have to have a comms critical cookie, a user initiated action cookie, or consent. There is no legitimate interests in cookie consent. I know that there are products out there that purport to offer that. They are wrong. You will be breaking the law if you use them. You'll probably get away with it, but it doesn't look good, and it's rude. So yeah, no legitimate interests in cookie consent, ever. Okay, here's some examples of don't do this. This website uses cookies to improve your experience. By using our website, you consent to all cookies. This is back to, by attending this session, you agree to pledge me your immortal soul. It's not consent. And there's no option to say no, so it's not freely given either. Deceptive design. We bake some cookies that you have to accept if you want to enjoy this website. It simply doesn't work without. I actually did a cookie audit on this site, and that wasn't true. In order to gather information and improvements, we should use some third-party cookies too, can we? What does that even mean? And when you go to the manage cookies, you've got pre-ticked categories which don't explain anything either. So yeah, that's not informed consent, that's not freely given, it's not even specific. Manipulative design, making it so hard for the end user to say no that they give up and just pretend that they've said yes. Bad. It's not good. Apart from not being lawful, it's rude, and it gives people a negative impression of your site. So yeah, making it too painful, and that includes hiding the granular consent options under layers and layers and layers of clicks. Rude. Don't do that. Pre-ticking boxes. Pre-ticked boxes are not valid consent. It's deceptive design, it's kind of manipulative, it's not informed, freely given, specific, unambiguous, evidenced, and remarkable. You can tell how many times I've given this talk, can't you? It just rolls off the tongue. So do not pre-tick consent boxes. And illegitimate interests. Again, I can't say this enough times. You cannot set cookies on the basis of legitimate interests. There is no such thing. So this isn't in the world because it's kind of small and dark and difficult to read, but content-wise, this is actually one of the best cookie notices I've seen. And I'm not surprised because it came from a law firm where their data protection lawyer is one of the best data protection lawyers in the country, so you'd hope they get it right. By the way, the slides will be available and the recordings between the 19th and 21st of October, so don't worry if you can't read everything on the screen there, you'll have the chance to get up close and personal with it later on. The good things here, we've got three options. We've got I accept, yes to everything, I do not accept, no to everything, or manage consents, which is where you can choose which bits to say yes to and which to say no to. That is optimum. It is higher friction, but we have friction for a reason. Brakes work by friction. Friction is a safety feature, and in this case, the safety feature that's being protected is our privacy, our rights, our autonomy, our agency, our right to exist as an independent unit in the digital world. Here we go. So, because all this is terribly complicated, I put together a flowchart which is terribly complicated. But as I said, this will be available on the slides. This is a decision flow for, do I need to get consent for this cookie? And what does consent look like? And I invite you to go away, print it, stick it up on the wall, and use it as often as you can, because the world will be a better place if you do. Okay, so shameless plug time. This is me, this is where you can find me. Please come and find me, I need the work. Oh, I need the money. I love the work, I need the money. And I would like to say thank you very much for your attention this morning, and I hope that's been useful.